Hello, and welcome back to the Mission Mediation podcast. My name is Jonathan. I'm a mediator, founder, and partner at the Pact. And today I'm joined by a very, very special guest. I have Laila Olapalli joining me from Bangalore. She's, of course, a senior mediator and the founder of Camp Arbitration and Mediation Practice. Laila ma'am is, of course, on the panel of multiple international mediation centers and has done profound work in this space. Of course, she's a legend of the game. We all know that. So I'm not going to spend time introducing her resume to you. All of you joining us live today already know that. And I would need more than an hour to just do that bit. So I'm not going to waste time doing that because we want to get into the mind of the mediator, that is Laila Olapalli. She's been in the space for almost over a decade now, I think, Laila ma'am.
More than that.
More than that. And I think I'm so excited to be doing this with you. We've been on this Mission Mediation podcast now with 6 episodes, and I'm really, really lucky to have you on this one. For those of you who are joining us live, and this is the first time you're joining the Mission Mediation podcast, we have other episodes with some fantastic guests. So do join our YouTube channel. All you got to search for is Mission Mediation by the Pact, and you'll find a lot of more fantastic episodes on mediators, mediation advocates, the role of mediators, the process of mediation. So a lot more for you to get curious about of how mediation works in practice. So this is a space where we don't get aspirational. There's no philosophical talk. This is conversations with real mediators doing real work day in, day out. And for those of us who don't believe that mediation is actually happening in India, that's why we created the Mission Mediation podcast, that we speak to mediators who are actually making it happen. All right. So for all users out there, whether you are a lawyer, whether you're a business person joining us today and you want to be more curious about private mediation and how that works, today is going to be that conversation. We're going to deep dive into what are the core essentials that make private mediation unique. And today's focus, of course, is process design. And we can't wait to dive into that, of course, soon. But I remember 5 years ago when COVID hit us, you remember those days? And we were struggling to get onto a Zoom call, all of us.
Times have changed.
And we were scrambling. And look at us now. We are on a podcast, going live to a broadcast. But it's a good turnaround, and I'm so happy to be speaking to you today. So for those of you joining us live, by the way, use the LinkedIn comment section. You also can comment on YouTube and say hi to us. Tell us where you're joining us from. And as Laila ma'am and myself dive into this topic of process design in private mediation, you might have some comments, you might have some thoughts, you might have some things you don't agree with us, and that's okay. Use that comment section. Tell us what you think about differently, maybe, or if you have a question for us, you can pop that in the comment section as well, and we'll try and address that during the course of the next 45 to 50 minutes. So on that note, I want to kickstart this. I want to get started and get in the mind of the mediator here sitting with us. So process design, what does that mean? It seems like a very simple question, and I want to put that out to let them straight away then say, why is it such a unique factor in the world of private mediation? Because a lot of people say they're engaged in mediation in India, but I would argue that 90 to 95% of those people who have experienced mediation have experienced it in a court-annexed scenario or a court-referred mediation scenario. And I would say a very, very small minority gets to experience the luxury of private mediation, the space of private mediation, the luxury of time, the luxury of the mediator's time with you, which is very crucial. And one of the most beautiful aspects of private mediation is the ability to co-design the process. We talk about mediation being a nice, flexible process, and the ability to co-design the process with your mediator is a luxury. And I want to dive straight into that right now, Ledman. So tell us what makes private mediation unique in terms of process design.
So Jonathan, first I must thank you for this opportunity. And it's really a pleasure for me to be having this conversation with you. I've seen you for many years in your mediation journey. And today I'm proud and happy to have this conversation.
Thank you. Thank you so much.
Yeah. So, yes, process design is a very important part of mediation. If we look at every dispute, it has a set of unmet needs. But every dispute is different because the facts are different, the people are different, the conflict experience is different. So we need to customize the process in order to maximize satisfaction. And customizing requires focused attention. When we look at court mediation, and I've been a part of court mediation for many years, the priority there is numbers. Cases are pending, it has to be disposed of. The mediation is pro bono. So the mediators are handling several cases and they need to quickly dispose of these cases. So they're focusing on the outcome and how to get the outcome as soon as possible, as quickly as possible. Whereas private mediation, parties pay for it. Mediation is voluntary. Very rarely do the courts direct the parties to go for private mediation. So they come on their own volition and they leave if they are not satisfied with the process. So the mediator has to ensure that there is maximum satisfaction. So while the numbers are the priority in courts, and therefore they standardize the process in order to get quick outcome, the priority in private mediation is satisfaction. Maximize satisfaction of the parties. And in order to maximize satisfaction, they not only look at the outcome, there is another important factor they have to look at, and that is how are the parties feeling in the mediation. There is a famous quote by this American poet, Maya Angelou, who I really enjoy. And she says, people may forget what you said to them. People may forget what you did for them, but people never forget how you made them feel. So, in order to maximize satisfaction at private mediation, the mediator constantly is keeping an eye on the outcome and on how the parties are feeling. And as we all know, Jonathan, there is this famous concept in the mediation language called the satisfaction triangle.
Yeah.
We kind of describe the process and the satisfaction through a triangle, the three arms of the triangle, which are equally important. For satisfaction, each of these arms are important. And what are those three arms? Procedural satisfaction, emotional satisfaction, and outcome satisfaction. I'll briefly go into each of these.
Yeah.
Procedural satisfaction. When parties come into a mediation, they need to feel that the process is fair, it's transparent, impartial. They need to feel respected. And as we design, this is very important. How do we uniquely provide these things? How do we customize it? For example, let's look at respect. We look at the parties. Some parties like a namaste. Some parties like a handshake. Some may like an arm over them, a gentle arm over them. Some might like a bow. Now, a mediator is uniquely customizing. What about safety? Parties need to feel safe. How do they feel safe? Have I how can I explain the concept of confidentiality in a manner that these set of parties are able to cognitively understand this is a safe process? For example, I remember I was doing a commercial mediation, it was virtual. Parties and lawyers were all on the screen, and then I see this, sign, admit. So I
Hmm.
didn't know who that was. I asked the group, who's this person? And one of the lawyers said, oh, that's my colleague, please admit him in. Immediately, I asked, has he signed our confidentiality agreement? As you know, in private mediation, they all sign confidentiality
Yes.
agreement. And he
Yes.
said, no. While on the screen, I contacted my case manager. She sent him her form, and he signed the form to confidentiality, and only then he was allowed entry. He was admitted.
Hmm.
So you can imagine immediately everybody feels, okay, this mediator is ensuring safety.
Yeah.
What about, concept like self-determination? We might often say self-determination, but have these parties understood their responsibility to take a decision? Unlike in arbitration, I'm not deciding, they are deciding. So have they understood that responsibility?
Yeah.
So these are another important way of ensuring the process satisfaction. Having the right people on the table. Have I set up the table in such a way the parties have all the people who are required to make that decision? Not only the obvious parties, but sometimes even the not so obvious parties. As we design, we bring in everybody. Similarly, information. Do the parties have enough information to take a decision? Documents. Do we need experts? Do we need
Yeah.
surveyors? So these are all aspects we look at during procedural satisfaction. Now
Can
we
I
come
just
to
come in there, Laila ma'am? I think that's such a huge point, right? We talk about procedural or process satisfaction as one of the sides of that triangle, and you're absolutely right. When you're talking about court and ex mediation, there's only one side of the triangle that's focused on, and that's outcome. Emotion and procedural is not given that much attention. I've had a situation when I was mediating once where, uh, one side just ambushed the other side by bringing a litany of, negotiators to the table. There were around 14 of them, and the other side were just sitting with a CEO and a junior associate, and they felt quite ambushed. But in my head, I was thinking there was something more to that than just they feeling ambushed. Because when I went to the other side, they had a different view to it, where they said, "What is happening? We are coming here with a very serious intention to settle, and look at that side. They've just come in there with two people, the CEO and a junior lawyer. What is a junior lawyer doing here? I've got two QCs sitting next to me. So are they even serious about mediating?" So when you first look at it, it feels like it's an ambush. But then, I guess that's where the neutrality mode of the mediator kicked in, where I said, listen, I'm seeming to empathize with them a lot right now because they're feeling like they're ambushed, but let's go and listen to what they have to say as well. And even, by the way, we had actually done our homework. We had our sports sides, who's coming to the table, but they changed that without letting the mediator know. So it made us feel like we are the villains in the story. But these things happen. But I guess at that point of time, it's then to manage that, because that's a live situation developing at that point of time. And you, as a mediator, you will agree that you're in charge of that process. You want to keep them feeling safe. Psychological safety is very important. And so I think neutrality is a huge I would say principle that's tested in process design as well. So maybe some thoughts on that from your side. Maybe you'll have an
yeah.
example as well.
So in your example, I can well understand
Yeah.
how you were, confused by the numbers. And
Yeah.
I can also give an example where in a situation where there were 25 people on one side and three on the other.
Right.
And there was nothing I could do to trim that.
Hmm.
But what I did was I addressed these 25 separately,
Right.
explained mediation to them, and then helped in gently selecting a few that could come then into the mediation. So the mediator does different things. They shouldn't feel the power imbalance.
Yes.
Parties feel overwhelmed when there are so many on one side and a few on the other, a clear power imbalance. So a
Yeah.
mediator, again, Jonathan, is a good point. How we customize it. In each situation is so
Yeah.
unique. What we keep in mind is, does this procedure look fair?
Hmm.
Now to move to the second arm of the triangle, which is emotion. A mediation requires space for authentic expression. The parties need to feel comfortable to express their emotions. Very often, emotions are suppressed, but those emotions are very important in mediation because two factors. One, when emotions are worked with, parties are more calm, more comfortable, more rational. Another important reason why emotions are important, beneath those emotions lie several unmet needs of the parties. So when a mediator sees emotions, remember it's a treasure trove. That's where you pause and you work with the parties to surface the unmet emotions.
Right.
That's a second arm of the triangle. Once these two arms are worked
Can I
with,
just pause you there? From a process perspective and emotion arm of the triangle, because once again, and I know you would have so many experiences of this sorts where uh, it is once again the responsibility of the mediator, and we're talking about process design here. We're talking about making sure, because see, and you and me know this during our time at camp, we sometimes spend months to just bring the parties to the table, right? It's months of efforts, emails, calls, convincing them that they should try this out, for their own sake, and give this the first. And sometimes they're already deep into dispute, they are deep into conflict, there are dozens of court cases against each other, but sometimes they're quite early in conflict as well, and we say, hey, before you go down that route, open this door and try it out. And there's a lot of time that we spend, sometimes weeks, just bringing them to the table. And as a mediator, we have that positioning to understand what their emotional outlook is like. And if we feel that they are not ready to come to the table together under the same roof in the first instance, we have to prepare them, right? We have to prepare them for that moment. I know that you like in your practice to have a first joint session. Would you say that you do that no matter what the emotional outlook is of the parties? Uh, or is it more of, okay, if you think it's really tense and there's a lot of friction there, then you might not start with a joint session. You would prefer starting with a few private sessions and then eventually build up the joint session. From my experience, I think I like to look at it both ways. And if the parties are not ready, then I give them the time to prep for it. That way, they also build trust with me as a mediator that I have control over the process. But I just wanted to get it from you. What is it a hard fast rule where you do start the joint session no matter what the emotional? Uh,
Jonathan, nothing in mediation is hard fast.
True, true.
That doesn't mean there is a structure. There
Yes.
is a structure, and our objective is, in the beginning, bring parties together to at least break the ice,
Yeah.
and if they're able to, help them to explain their perspectives to each other, help them to understand how the other's lawyers are looking at this, so they start with enough information on the whole picture. But safety is the most important.
Right.
If a mediator feels that bringing them together prejudices safety for the party, no. We start with private session. We work with them till they feel safe enough to meet the group. So
Yeah.
this is all part of the designing. You use Private sessions and joint sessions are tools in the hands of the mediators to use as required to achieve the right objective.
Right. So that's a very crucial thing there. Once again, in terms of process design in private mediation, the luxury of having time to study the emotional outlook of the parties. I mean, we're expecting the lawyers to have good emotional intelligence, so that's already something very assuming and we're hoping for. But the parties, we have that luxury of time to study what, because we see this kind of odd moments in court and next mediation centers where you'll have you know, these physical fights sometimes and these verbal outbursts, and we see these things going viral sometimes on YouTube or other places, and it gives a bad name. It gives a bad name for a process like mediation. And see, people who are aware of what private mediation looks like will say, we know what's going on here. They didn't have the luxury of actually designing this well, because in private mediation you would not let that happen, because you would know that these people are not capable of sitting under the same roof. I can understand a Zoom call. I can understand a Zoom call where there's a bit more opportunity to discipline and control. But in a physical setting, if you know that person's going to go after them physically, you're not having that first joint session. And so I think we must appreciate that luxury that we have in private mediation, to be able to study that emotional side for the parties before we bring them together.
You're right, Jonathan. Definitely, we have the time. I also would like to add that as a mediator, I welcome those emotions sometimes
Yes. Yes.
because that gives me a lot of information. I understand the dynamics between the parties, but at the
Mm.
same time, a mediator has to be equipped to ensure that the parties don't go beyond control. You have to protect, one of the ethical responsibilities of a mediator is to protect the safety of the parties.
Yes.
So that's why process design is very important in private mediation, because all these things are, I think it's Abraham Lincoln who said, if I was given 6 hours to chop a tree, I would spend 4 hours sharpening the axe. When I
Yeah.
had actually gone through this initial phase of mediation, I almost say, ha, now a lot of my work is over.
Right.
Because this is the intense part of it, the
Yeah.
preparing for the mediation. So, yes, emotions are welcome. I work with emotions. At the same time, safety and comfort of the parties is priority.
Can I just, I know we want to get into that last one of the outcome, but I just want to dive deep into this book. I think this is such a fascinating topic. And especially in the world of workplace mediations, where, I've spent a lot of time in the last few years. I would say there is a lot of attention given to, say, coaching, right? And I know that in a space where, in a jurisdiction that is still kind of embracing mediation, like India, uh, I don't want to complicate things, but as a mediator, I feel very comfortable spending time with both sides, kind of coaching them to, in terms of what's expected out of them in terms of behaviorism in a mediation, coaching
In
them
terms of, Jonathan, let me pause you there. I didn't hear you. What did you say? You spend time coaching them for what?
in behaviorisms, what's expected out of them in the early stages, in the middle stages, in the final stages. Let's take, for example, you say emotions are very much welcome, and I completely agree with that, because sometimes you just need to you need to loosen that in that clogging that has happened. They need to vent out. That's an emotional clog there. Uh, but once again, it helps if it's done in a way that does not put us on the back foot, that does not take us 10 steps behind instead of going further and forward, right? So I wanted to check on you on how you do this, but I like spending time with my, and this is something I picked up while I was doing my masters in Scotland, where you spend time with your parties, helping them rehearse their opening statements. You're not drafting it for them. You're not saying what to say. You're saying, would you like to share your opening statement with you? You have around 10 minutes tomorrow before our mediation. Um, what do you think you're going to say during that time? Would you like to just share that with me? And the only reason I'm asking you to do that is because I want to see if there's anything there which might make the other person leave the room and walk out of the door. And I don't want that to happen because we have worked hard to have this tomorrow. Um, and I like doing that. Do you get involved in that space? Is that something that you like doing as well?
So, Jonathan, my style is more free flowing.
Okay.
I, of course, I ask them how much time do they want for their opening presentation.
Okay.
That kind of streamlines the time that they would take, and they also prepare for that presentation for the time indicated.
Right.
If I see something going untoward,
Hmm.
I give them a few minutes to play that out. Sometimes parties like it. I ask the other
Yeah.
side, are you comfortable with this conversation in the presence of the other side? Do you think this is productive?
Hmm.
And if the other side says this is not productive, then we get an agreement on how the communication style would be. We all agree to it. We proceed by agreement. And the next time they breach that, I remind them. You remember, we agreed that we will allow him an uninterrupted conversation. Can we just
Yeah.
go back to that? So, it's a process of gently proceeding by agreement. That's
Yeah.
my
And I think
style. I'm sure everybody, each mediator has their own style.
absolutely, and we are all in for it. I think we can conclude this segment by saying that for all of you joining us live, and please feel free to comment with your own ideas on this. But if you have heard Laila ma'am and myself for the last 5 minutes, we do have two different styles the way we handle this. But if you notice it, both of us have purpose and intent to what we are doing, and that's what I want to highlight once again. Because we're talking about process design, we're not just winging it. We're not just walking into a mediation room and saying, let's see what happens. That's not the attitude of the mediator. The mediator is very much involved, very much present, and everything that the mediator does, whether it's before the mediation session or during the mediation, is properly thought out. It's purposeful. It's intentional, and it takes a lot of, I would say, insight before we do what we do. I'll let you move into that third space of outcome satisfaction now.
So the third R, outcome satisfaction. When we have worked on the process, when we have worked on the emotion, organically, the outcome is superior. We have understood what those unmet needs are. Interest based negotiation is facilitated. Parties feel satisfied with the outcome and feel satisfied that they are able to create different options. So that interest based outcome is a superior outcome. And along with that, one important factor which I want to mention in private mediation is the perseverance of the mediator. The mediator, the mediator's perseverance is something that the parties really value. You go back and forth until there's no value left on the table. Everything is kind of optimized. The parties then feel that they have a good deal. They have the best deal because they've seen the mediator fine tuning, getting the best possible. So the outcome, I would say, is superior because it is interest based. By interest, I mean what are the underlying unmet needs and how do you address it. So the outcome is interest based. Outcome is arrived at with a lot of hard work by the mediator, going back and forth. So finally, this is what I would say customization does for private mediation. It
Yeah.
creates maximum satisfaction. And this is possible in private mediation because of the fact that the time constraints are not so heavy, and you have to get selected in the market. World over, it is the mediators who excel are being picked up in the private space. That's why the market looks like a pyramid. Those who are good keep getting taken. The others, it's more challenging. So the private mediator has to excel.
Absolutely, and you have to feel comfortable excelling in that space. Especially as I was having this conversation with a very senior mediator who's very much involved in court and ex mediations in India, and I said that considering that you are, literally pounded with 5 6 mediations a day, court and ex mediations a day, and because that's your mindset, that's your pace. You're working at a different pace, right? If you're doing 5 6 mediations a day, um, the way you operate, your temperament is different because you're operating in a different timeline, a different, I would say, space. And suddenly when you're pulled into a private mediation, it requires sophistication and expertise, and as you said, you have to excel, and to excel you have to be comfortable in that space. Because if you have the temperament of that you need to get solutions done in the next 1 hour because the next mediation starting in the next half an hour, do you have that? Can you then calm down, and can you switch into a more relaxed temperament when you have, because these seem like simple things, right? But this is the psychology of mediation. I'm saying if you're used to a certain temperament, and tomorrow you're doing a very complex private mediation, do you have the temperament to actually, you know, relax, calm down, find your composure, and then work within the luxury of space? Are you comfortable working with the luxury of space, using that? Because that's so beautiful. That's the place where you can really excel, right? But you gave us a fantastic quote like just 2 minutes ago, and you said private mediator or a mediator in private mediation is, you know, always persevering. Perseverance is a virtue of private mediators. And I would like to point this out to the audience joining us live. That's a different word from persuading, because I think a lot of users, a lot of lawyers think that a mediator has to be persuading, a mediator has to be persuasive, right? Someone who has to go and convince the other side or persuade the other side that take this deal, it's a good deal. But that's not what a mediator does. Mediator is not expected to be persuasive or persuading, but persevering, I think, is it's a better word, where the mediator does not give up. That's a really, really interesting insight there. Thank you so much for that one. Because I think that really wraps up this whole idea of process design and why, it's so crucial that, the mediator comes and then uses that space, the luxury of space to do it. Now I want to dive into some of the examples that you have been involved in. So let's go straight into it. Give us some of your interesting examples of process design.
Okay. So we mediators always keep in mind that parties come to us with a mediation because their negotiation failed. So this time we have to set it up for success. So
Yes.
that's the most important part of a mediation. We have to set up the negotiation for success, and that's what mediation process design is all about. Okay, let me give you two examples. One is a family business mediation, and the other is a commercial mediation. To start with the family business mediation, I'll be focusing on how we design the process. So here was a mediation where, and I would want to say that the facts are collated. It's not from one particular mediation. Protecting confidentiality is very important. So this is not exactly a mediation that I have done. It's a combination of factors, that mediations that I have done, from the mediations I've done. So here is a family business. The father has been a strong leader, and the the mother or the wife. They've been together in business, the two children joined, and the father dies suddenly. And the mother and the two children are directors, equal shareholders, but the grief, the adaptive challenges of moving into a business where the head is suddenly gone resulted in a lot of differences, disagreements, fights. As I had these earlier calls with the mother, she is reluctant to come in for mediation. She says, I am traumatized. The children are fighting in front of the staff, morale is being impacted. I cannot face them. Um, I am grieving my business partner and life partner for 40 years suddenly left. I can't do this. And as we continued to speak, there was one person that she felt comfortable with, and that was her brother, her only brother. And she said, okay, if my brother is there at the mediation, maybe I can come. Then I speak to the children, and of course, I see the same turbulence, the difficulty to talk to each other. And the son says, I will not come for mediation if I even see that uncle. So, and for everybody, reputation in the family is important. Nobody in that town should know about the quarrel. The 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 siblings, they tried to kind of divide roles, take charge of separate units, but they realized that their styles are very different. The son is a free spirit, and the daughter is, she's very particular about role boundaries, and almost obsessively so. So these were all challenges. What do we do? Um, and one thing that they kept saying, we want it all to be under the same umbrella. We don't want to divide this. But at the same time, when they tried doing it together, it didn't work. So I had some challenges. Challenge number one, how do we have the mother with the brother and the son in the mediation room together?
Mm.
So finally, we got an agreement that we'll start virtual,
Right.
and the brother would be available in the room, not on the screen,
Mm.
not seen on the screen. And each time the mother had to consult the brother, she would go off video and she would mute.
I
So
see.
we
But
had
he
this.
was in the room with her.
He was in the room,
Right. Okay.
but not seen by the brother, by the son. So it was a virtual mediation. So that's how we designed that. Then the next challenge, how can they work as a team? Even 2 to 3 minutes, they erupt. Communication between them is impossible. Then we designed it in such a way that the first few sessions of the mediation would focus on communication building. I became the communication coach.
Mm.
I used different communication techniques, and slowly their conversation, their communication improved. Third challenge, what should be the structure of the business? Where I'm not an expert on business governance and organizational structures. So, and at the same time, they don't want anybody from that town to come in. to the mediation, except one financial consultant, family, who's been in the family for many years, but he should not be privy to any of um, the dirty parts of the dispute.
So he only sticks to the numbers and the finances.
He only comes. So then, how we structured it was, we'll bring a business consultant towards the later stage of the mediation. All the professionals that they would engage, that is the lawyers, etc., would be from outside the town, not from that town. Once we have gone with the earlier washing the dirty linen part, and we've kind of reached a place where the consultant can come in, he comes in, and then finally the family financial consultant who's been part of the family, he will come in to give his inputs. So we structure it in such a way that all the challenges that we anticipated would be comfortably dealt with. So that was the process design.
I like that. I mean, if I can just come in there, I think one of the big responsibilities for you there, while you're designing this as a mediator, is kind of preserving the circles of trust. There are, multiple layers of circles of trust. If you see, they obviously want to keep this confidential, and that's why private mediation, we need to respect that. They have conflicts among the stakeholders, that is the family members there, but that is still within that circle of trust. That they don't want that to go out to the financial folks and the experts coming in. So there are stakeholders and the experts. So there are multiple layers, I would say, of trust there. And as a mediator, you need to maintain that, and it can't overlap, right? And you might be thinking you're already in dispute, but and so these people are here to help you, but no, even though they are in dispute, they are in dispute within that circle of trust. They want to keep it in the family, and I think that's once again a fascinating aspect of the mediator,
And
preserving that.
yeah, and Jonathan, as you rightly said, there are layers
Yeah.
of issues that you deal with. But whatever we do, we proceed with agreement
Yes.
together. Everything is co-designed.
Right.
They express their challenges, the mediator works around it, and co-design the process.
Yeah.
So
Yeah.
that's an important part of this designing. It's co-designed.
Absolutely. Yeah. Something that we said right in the start. That's the luxury of doing that with the mediator, and
Yeah,
having space and time to do it.
yeah.
I think that's a fascinating example. Thank you for sharing that, Leila ma'am. I think you have another one for us
Okay,
in terms of process
yeah.
design.
So the second one I'm going to speak about is a commercial mediation. The dispute was referred by an arbitrator.
Okay.
Arbitrator highly suggested that they go in for mediation and get a consent award. So they come in for mediation. It's a construction dispute, developer and co-developer between two international firms. And we had the initial conference call. Company A comes into mediation with the CEO, the legal head, the external counsel, uh, and company A, the lawyers had earlier participated in mediation at CAM. Company B comes in for mediation with their legal head, an elderly gentleman, very respected and close to this business, the management, highly trusted by the management, and all the legal counsels, the legal head and the external counsels. As we mentioned earlier, I'm immediately seeing a slight power imbalance. And they've never done mediation before. Company B has never done mediation before.
Right.
Um, as I hear a little more, I understand that this appears to be a dispute Between the two CEOs,
Mm.
there were difficult conversations between the two CEOs. When I suggested the CEO from company B should also come, this elderly gentleman, the legal head, stands like a wall between the management and me. He says,
Mm.
no way. He's been representing at arbitrations for several years. He's never brought the management in. So he just couldn't think of having his management in. So then I asked for a separate session with just this elderly gentleman with the permission of the other side, all concerned, and they all said fine. I spent about 2 hours explaining to this elderly gentleman what mediation is, how it is different to arbitration,
Right.
where the responsibility of decision making lies, what are the factors that influence the decision. Once he understood all this, he agreed for the CEO of company B also to come in. So the table became balanced.
Did
And
you see
he
a
also,
sense of did you see a sense of insecurity, or was it mostly ignorance of the process?
I think it was not insecurity, it was his understanding of how a dispute resolution process should take place, and
Okay.
he should not expose his management, which he normally does not in
Right.
the other dispute resolution processes that he's done.
Yeah.
Then, as we continue the designing, so here was
I'm sorry. I just want to once again point that out there, because because you did that, because you took time out, took out those 2 hours, and that's once again a private mediator does that. This is the insight of the private mediator, the intuition of the private mediator. Say, it seems like he is not there, he's not present, and if we want him to participate with the right intention, let's get him on board. Let's get him on board with us. Let's not make him the villain in this process. So that the fact that you took time and spoke to him, and you understood, and also he understood, because I think that's a great thing there. He was not being insecure, as you said. He was just being protective of his management. He doesn't want to expose them. He doesn't know what's going to happen. And when you understand that as a mediator, you can then understand why he's probably participating the way he is. I think that's a
yes.
beautiful example once again.
And Jonathan, thanks for pointing that out, because one thing I want to point out is mediation is almost counterintuitive in conflict.
Hmm.
It is so unfamiliar
Yeah.
that for the mindset to shift from the adversarial to collaborative problem solving takes a lot of time and effort. And we mediators should
Yeah.
always remember, we throw in concepts like self-determination, voluntary, but remember, cognitively parties have not understood it. And it is
And it's your curiosity as a mediator to understand why. We always talk about the why to the what.
yes,
And
yes, yes,
if you don't take time to understand the why he's probably being a bit passive and not getting
yes,
involved,
yes,
if you don't
yes,
understand the why, you will start getting frustrated with him. You'll start getting annoyed with him and angry and
yes,
upset, and you will always blame him as the one who's not making the settlement come through. But
yes,
what you did there as a mediator is once again a brilliant example of what a private mediator does. Takes that time out to understand the why of how he is behaving. So I
yes,
think that's brilliant. Sorry, I interrupted you there, but please carry on.
yeah, yeah. So then to design this, I knew the two CEOs, they are CEOs. So I need to respect that. We set up a separate conversation for just the two CEOs and myself, where they could break ice. Then I also understand the CEOs, during this, I understand the CEOs are seeing this differently because they are being briefed by their technical teams.
Yeah.
They have not heard the other technical team. So then we had a joint session of the CEOs, the lawyers, the external counsels, two technical teams, and the CEOs could then hear the conversations between the two technical teams. They could see where the differences were and what were the perspectives. When that became clear, the mediation moved forward.
And this session with the technical teams, was it a joint session or was it more of a cross?
All a joint session.
Okay. Yeah.
This was a big joint session. The two technical teams, the financial experts were there, the parties were there, the CEOs were there, the lawyers, the external counsels, the in-house lawyers, everybody together. And it's like removing the blinds, that famous
Hmm.
story of the elephant, and somebody who's never seen an elephant blindfolded saying what the elephant is. And when you
Yeah.
remove the blindfold, they see the whole picture. So we created that opportunity through designing for the
Yeah.
whole picture to be understood. So that helped the mediation move forward. Then I'm going to tell you other things that we did to
Hmm.
design. This was a construction dispute. It has been going on for the past 8 years. The construction site has been abandoned for 8 years. I noticed that nobody really is talking about what is the current status of the construction site.
Right.
So there had to be an inspection. We organized we fixed the date and the time where the two teams would go for a site inspection.
Hmm.
What is the current situation? They will go with the senior people in their staffs at the same time. But I also had another commitment from them. They would go to the site, understand what the problem is, but will not work on the solutions.
Hmm.
The solutions will be on the mediation table. I would have gone with them for the site visit, but it was another city, and they assured me that they were okay. And I constantly monitored this, and that's what they did. They went, did the inspection, came back to the mediation table to discuss the solutions. So that was another decide. Third, these were two international companies from the same country.
Right.
There, I assumed that their culture for decision making would be same. What is a hierarchy and things like that.
Yeah.
I quickly realized it's different.
Okay.
One was a recently acquired Indian company by
Hmm.
the international company. Parent company was international, but it was recently acquired. The
Right.
other was historically an international company.
Okay.
So these cultural differences were aggravating the misunderstandings.
Hmm.
I had to notice it and work with it. Again, designing. Finally, we find the terms of settlement. Now, commercial disputes are heavily lawyered. So the lawyers, we have a settlement. Now we need another 4 5 months to draft the final document, which will be filed with the arbitrator, who will then pass a consent award.
Yeah.
But the arbitrator says, no, I can't give you that much time. He has a time constraint. And I also know lawyers take these terms of settlement. There is a risk in the back and forth of the legal language. A lot can happen. So
Yep.
then what we all agreed is these terms of settlement, the legal language will be decided on the table and we freeze it. Then the other stuff they can do back and forth.
Okay.
And that's what they did.
And that was mutually decided by everyone on the table once again that this is the best.
Everything in mediation is proceed by agreement.
Yeah.
Everybody agrees. So they all agree to that. And what could have taken a couple of months happened in a day or two. So lawyers for take, they want this agreement to be drafted very legally tight, watertight. They take time. I remember an IP dispute that I mediated, intellectual property dispute. The actual mediation took 20 hours, and the drafting of this took another 20 hours because lawyers are so very particular. So these are some of the ways in which we design the process. And to conclude, what I need to say is that, mediation, the process design is structured, it is in layers, it is moment to moment, it is organic, it is a created by the parties and the lawyers and the mediator. So it's a team effort.
Absolutely. And you've summarized it so well, Ailaman, with such fantastic examples. It feels like we have just covered the tip of the iceberg here in terms of process design, but what a brilliant introduction to this topic. And for those of you who are joining us live and those who will watch this on recording, we would love to hear from you. I'm sure you can write to us once again at Camp Impact. Tell us what you feel about it. Get to understand more about how this feels. But this three different aspects you talked about with regards to this last example. Having the technical teams meet together, the on-site visits, and then of course once again the cultural differences. This is all that you don't see on the tip of the iceberg. That's all beneath there. And the curiosity and the willingness and the perseverance, as you said in the start, of the mediator to get to these things. Because if you don't fix this, if you don't address this, then you're going to face roadblocks and you get frustrated with the roadblocks. I think this is really fascinating. And this is all part of process design, but this is also shows you what the role of a mediator is in terms of getting to the why. Why this is happening, why this needs to. I have before we. I know if we can do this in the next 120 seconds, it'll be great, because I remember a mediation that we were part of together when I was at camp, where I remember, I don't know whether it was you mediating this one or someone else on the team, but I remember a place where we got the parties together and we were helping them come together, and we were setting the process up, and they were having their own separate conversations on the side, and they were messing things up for us. I don't know whether it was you involved in this one, but and I remember I was getting frustrated with this, and I came back to you and I said, "Ma'am, do we allow them to do their own thing on the side, or do we control the process?" Because remember, they have started the mediation, right? They've reached out to us that we want mediation. They've appointed a mediator, and now they're doing their own conversation on the side, and it was not helping. It was making things worse. And this brings me back to this thing where you allow these folks to go to the site visit. It might help them bond, but at the same time, you're like, this can aggravate. Say someone says something to the other person, or the blame game starts. It's a tricky one. So I'm wondering how comfortable you go with this, and
Yeah, you're right, Jonathan. But we lay down clear rules,
okay.
and I would have been part of that site inspection, but I felt confident that they would comply. We had strict rules on what they would do and what they wouldn't do. Guidelines were formed, and that's how we
Yeah.
did it. Yeah,
Okay. So there was
you're
a
right.
clear purpose.
Yeah, there
Clear
was a clear
purpose.
purpose, clear guidelines, and I kept monitoring it. So it was good.
And you said that's not a place to discuss solutions. Just try and understand what's going wrong,
Yeah,
and let's come back to the table.
yeah,
I think
yeah,
that's brilliant.
yeah.
And even with the technical sessions, I think what you said to them was, this is just to understand both technical teams. We're not here to counter. We're not here to say we disagree. We're just here to listen. And I think that's once again the luxury of process design, where the mediator says, listen, the next one is only to listen. Even if you don't like it, we're just going to listen in, so that, because we've not heard this part of this perspective before, so let's just hear it, and then it's time to disagree or agree or whatever it is. Brilliant. What a fascinating session, Leila ma'am. I didn't expect anything less than this with you online with us. For those of you who joined us live, thank you so much being part of this episode, and we will share this live, of course, this recording. It's going to be on YouTube and on LinkedIn, so you can watch it anytime. such a fascinating conversation once again. Laila ma'am, thank you so much, and I'll see you soon.
Thank you, Jonathan. Thank you very much. I enjoyed it.
Thank you.